Okay, hey friends, hey everybody. Paul Rabelais here again, estate planning attorney. Excited about today's live stream. Just jumping into this state-specific series that we have, and excited to have Jonathan Lerner here today. And we're going to talk a lot about estate tax for residents of Connecticut. We're going to talk about some other estate planning issues. So the first thing I want to do is really introduce Jonathan. Maybe you can, Jonathan, share with us a little bit about kind of your background, how you chose estate planning, and then we'll jump into some of the state-specific issues. So, Jonathan, welcome.
Great. Thank you, Paul. I'm really excited to be here. Well, my journey to estate planning and trust in estates in general, really, we have to go back even further. Growing up as a child in Connecticut, we were always asked, when you grow up, what type of doctor do you want to be? I come from a family of physicians. My two younger brothers are physicians. My father's a physician. Grandfathers were physicians. Um, so I was supposed to be a physician. Ultimately, through college, at some point, I decided, you know what? If I'm scared to get a blood test, I'm probably not really suited for medical school. And at that point, the option really was, if you're not going to be a doctor, you could be a lawyer. So I went on, didn't really give it much more thought, just sort of was pushed along that track. When I got to law school, I knew early on that I wasn't going to, really thrive or love litigation. I wanted to sort of deal with people. And then in my courses, when you take your required trust and estates course, you realize that's what you're doing. Ultimately, trusted estates is what I found to be the closest to sort of psychiatry or psychology. And that's sort of where I then went. I then sort of specialized, to the extent that you don't really have a formal major, but you can choose electives based on your interest in law school. I chose estate planning, post-mortem estate planning, estate and gift taxation, any course that really could sort of lead me on that track. After graduating law school, I went to a boutique trust and estates firm. It was a good experience and good training in terms of drafting and learning. It didn't give me much exposure, though, to clients. It was one of the firms where the partners see all the clients. In my 5+ years there, I think I was in 2 meetings and actually saw people. And that's not what I was looking for. So, of course, sometimes people are reactionary. At that time, I said, okay, this is not for me. I didn't really see a path forward, and I didn't yet feel the comfort to sort of go on my own. So I basically said, okay, maybe I made the wrong choice. I shouldn't have gone to law school. So what did I do? I actually left the law firm and joined a master's in social work program. So I got my master's in social work. I did some clinical behavioral counseling, did a per diem. I then actually found a very interesting job, a lot of fun. I was an associate dean at a small college where I really got to exercise my social work skills, working with students, advising them for academics, but also sort of social things that are going on for college age students, the good and the bad. Um, but during the pandemic, I was working in New York. I got to stay home for a year plus and work from home. After the pandemic, I didn't want to go back to New York to commuting. So luckily during that time, during my university schedule, I was off on Fridays. So I kept my feet wet. I found a wonderful local attorney in Connecticut who practices tax and estate planning and also some business entity work. And he was looking for someone that could help out with the estate planning. So I sort of was re-venturing in. But again, after the pandemic, I said, I'm all back in. So that's where I've been ever since. And again, I've been enjoying my practice a lot more now because, again, someone calls up, they want to talk about their estate plan, I answer and I run with it. Again, for me, it's really all about knowing where the client is and trying to help them with the skill set that I've learned, which is the estate planning. But again, that's really sort of the tool I use to help. So I look at myself as sort of someone there to sort of help guide the clients.
Yeah, I'm looking forward in just a little bit here after we address some of these Connecticut state-specific issues. I'm looking forward to a discussion that we'll have about, as you said, the psychology of estate planning, how you apply your masters of social work to estate planning. So looking forward to talking about that. But let's jump into maybe some of the Connecticut estate planning issues. I was interviewing an Illinois resident 2 days ago talking about some Illinois issues. Illinois has Illinois, the state estate tax doesn't apply unless someone passes away and they have more than $4 million of assets. And there's a handful of states, lax. So what I'd like you to do is just kind of share the basics about what's this death tax, estate tax scenario for residents of Connecticut that people in Connecticut would need to know.
Right. So we do have an estate tax. In fact, I'll also sort of say we also have a gift tax. I believe we're either one or two out of one or two states in the union that has a gift tax still. But in Connecticut, just like most people don't have to worry about the federal estate tax at the moment, most people right now, beginning in 2023, we basically met the federal exemption amount. So right now, the first $13.61 million that an individual has goes Connecticut estate tax free. And then afterwards, there is a flat tax of 12%. Now, again, it's unlike New York where there's a cliff tax.
Yeah.
This is basically, again, only the first dollar after $13.61 million is taxed at the 12% rate. So that's the Connecticut estate tax. Mm-hmm.
Yeah, what about that gift tax? Does it apply on kind of gifts in excess of the $18,000 annual exclusion limit?
Exactly. So the Connecticut gift tax works similar to the federal gift tax. It's basically a unified credit that you could either use for gift tax or estate tax during your lifetime. Luckily, there's no Connecticut GST tax, but we do have gift tax, right? If you're giving more than $18,000 in a year, you have to report it on a CT 709. Now, this is also important to know because right now, one of the big topics for wealthy clients is about slats. Let's use up our exemption now so we don't have to, lose it perhaps in January of 2026. Now, for a long time, until 2023, the Connecticut estate tax and gift tax exemption amount was lower than the federal. So, for example, in 2020, we were already, for federal purposes, up to 11 point something million dollars. In Connecticut, it was $5.1 million, which meant that if you were trying to engage in some of these plannings where you're using your entire federal exemption before it was taken from you, in Connecticut, you would have owed a gift tax right off the bat.
Yeah.
So again, what a lot of people did in practice was we would fund a SLAT, a spousal lifetime access trust. We could talk more about that if it's of interest, up to the $5.1 million. And then the following year, the exemption amount crept up and you just keep funding that additional amount. So that's the Connecticut estate tax. We still have it, but again, it doesn't affect most people. Although again, we do tend to have a lot of wealthy clients. We're in Fairfield County, Connecticut. We have Greenwich as our next door neighbor. Westport also is a well-to-do town, just about 20 minutes from here. So again, people do pay estate tax, but again, not like it was. The other thing I would mention about the estate tax is that unlike the federal estate tax, there's no portability. So if you have two spouses, you can't automatically say, oh, we have about $27 million of exemption. You have to make sure you're using some during the spouse's death.
Right. Can't overuse that marital deduction and lump it all into the estate of the surviving spouse. Yeah.
Exactly. So
I find that on your slide discussion and your And what I find, you mentioned the estate tax on schedule to be really the exemption cut in half in 2026, and had a lot of discussions lately. I think the public is confused about what the rules are around this sunset of the estate tax exemption. Was talking to a single individual yesterday, had about a $12 million estate, which is larger than most, and a lot of people kind of mistakenly believe that they should be, giving away maybe $2 or $3 or $4 million now, while they have this $13.6 million exemption. But in reality, that gift of $2 or $3 or $4 million doesn't really do any good, because in 2026, the exemption will be either the greater of the exemption that they used during their lifetime, or the exemption in effect when they die. So really the people who are really taking advantage of this future estate tax exemption cut in half scenario are those people who can make the gift to the slat or to the descendants of that $13.6 million and use that exemption now while they have it. So I'm sure we're going to be having lots of discussions with people over the next year and a half, or year and a half, as what should we do? We've accumulated assets. The law is scheduled to change. Should we be making some large gifts? So this next year and a half, I think, is just going to be a busy year for us estate planning attorneys trying to get people ready for this sunset of the Tax Cuts and Jobs Act. So, are you seeing some discussions about that
We
in
see
your area?
discussions about it. Sometimes, we tell all our clients, especially, the owner of my firm tends to believe that, in all his years of practice, he's never seen the estate tax exemption go down. So
Right.
we always preface it with, on the books, the estate
Yeah.
tax is going to be cut, exemption is going to be cut in half, but we don't really know. And if you ask me, I think that we probably won't really know on January 1st of 2026, because again, Congress probably, if Congress is going to act, it might happen a few months later. So the truth is, I don't know that we'll have certainty even when we hit
Yeah,
January
you're right.
2026.
We don't know. I remember, I think it was 2010, the exemption was scheduled to go from 10 million to back to 5 million. And basically, boy, it was almost on the eve of January 1st. I don't remember exactly what day it was. Congress said, no, let's just keep it at 10 million. And a lot of people had done some planning in anticipation of the estate tax exemption being cut in half. So yeah, we don't know. So, okay.
Right.
So
And I would also
help.
just say, Paul, the other thing that we should
What's that?
remember is that, if we are doing gifting in order to avoid the exemption change, the truth is also we are losing some benefits which are guaranteed. Step up in basis. So the idea is, right,
It's a big one.
these are conversations that really have to be had with the client on a one-on-one, sort of look at the specifics and sort of make an evaluation what's best for this particular client.
Yeah. I mean, my last comment, we don't know what's going to happen, but yeah, the ideal scenario is, sometimes it's advantageous for someone to keep all of their assets in their estate. If we know there's not going to be estate tax, the advantage is if they keep all of their assets in their estate, then the heirs get the benefit of the step up in basis as opposed to the carryover basis on gifted assets. So yeah, lots of dynamics at play. So all right, what I want to move to now is, every state has their own unique probate rules. I'd like for you to share with our audience, what are you seeing on the Connecticut probate? What are some of the unique rules? Does it vary from county to county, area to area? What are some of the challenges that Connecticut residents face going through probate? Kind of share with us some of your experiences there.
Sure. First, I would say that Connecticut Probate Court, and again, I haven't made a study of all the probate systems throughout the country, but when we compare it to our neighbor, New York, the Connecticut probate system looks very informal. New York, they have real courts. In Connecticut, when we have a probate court hearing, we go to town hall and we meet around the judge's desk and we have a discussion. So again, the idea is in Connecticut, there's less formality, again, than compared to our neighbor, New York. But in general, when someone passes away in Connecticut, assuming there are probate assets, we have the client apply for probate to be appointed as executor of the will. And then the probate court has to collect an inventory of the assets. There has to be a return of claims filed for any creditors. And then also all estates, whether or not there are probate assets, have to file a Connecticut estate tax return, even for estates that don't owe any tax. It's called the CT 706 NT. NT, no tax. Again, this is the probate court's way of assessing a probate court fee. And the probate courts are funded through this. So even the estates that they went to, if they met with me and we got most of their assets, millions of dollars out of probate, because we funded the revocable trust, which we could talk about as well, they still have to file something with the probate court, and the probate court collects its fee on it. And it could be up to 0.5% of the estate value.
Wow. So if someone has, $4 million of assets passing through their revocable living trust, The probate court doesn't get involved in the transfer of those assets, but 0.5% is if I do my math correctly, is $20,000.
Yeah. Ultimately, so don't quote me on the exact amount because there is a
Yeah,
schedule. But again, at the
it's
end,
yeah.
it's basically 1/2 of 1%. And you're right. And how does the probate court enforce this? There is an inchoate estate tax lien on real estate. So unless you get the release from the probate court saying that yes, so and so passed away, we assessed, there's no further estate tax due, until that's on the land records, they have trouble selling property.
Ah,
So,
geez.
so it is something. So we've gone back for people that have died. I have one of the matters of my case. Someone died in 1995. The family never did anything, you know,
Mm.
until years later. So now, only years later they opened up a probate estate in order to do this, and then everyone comes out of the woodwork, and then of course family dynamics change over the years.
So are there any Connecticut residents saying, well, because we have this Connecticut estate tax that most other states don't have, we have a Connecticut gift tax, we have this additional expense that we have to pay, even though we've set up our living trust. There's a lot of expenses my estate, some people might say, will incur for me having the privilege of dying as a resident of Connecticut. Does anybody talk to you about, hey, maybe I'm thinking about moving out of Connecticut to avoid some of these expenses?
Yes, I just this morning actually, one of the clients called up just to say that thank you again. He's so happy that he established domicile in Florida. The truth is,
Ah,
it happens. Florida is a common sort of go-to state for Connecticut residents. Um, ultimately, but again, the truth is, I just want to push back one more thing. Actually, it's not just Connecticut residents. If you decide to buy a piece of property in Connecticut, real estate, something that's
yep,
really located in the state, there's a Connecticut estate tax return for non-residents. So you can't get out of it. It is something. It is something
yeah.
that's there. And
You,
anybody
you you
that
can
owns
run, but you
property
can't
here,
hide, I guess, huh?
exactly. So even those clients that ultimately take residence in another state, if they still maintain their old house here, even if they're not living there more than half the year, they're still going to have to file with Connecticut.
Yeah, yeah. Oh boy. Well, as you said before we started, it's a beautiful day in Connecticut. The weather's terrible outside for me here in Louisiana, so I know Connecticut has its great moments as well. So, all right, what I want to move on to, and maybe one more little Connecticut issue, and as I talk to lawyers around the different states, it seems like every state has these unique rules. Legislatures are now enabling its residents more and more to title assets in a way where they can attempt to avoid probate. In the good old days, it was, of course, IRAs and life insurance had beneficiaries. And then it was TOD, transfer on death with stock, POD, payable on death for bank accounts. Now we're starting to see a number of states enable people to title vehicles in a way where they name a beneficiary, title an LLC membership interest in a way where it can go to beneficiaries, real estate, homes as well, transfer on death deeds. And I realize sometimes it's not in the overall estate's best interest to kind of do that quickie, simple method when maybe assets should be in a trust. But I'm just trying to get an idea of what kinds of things does Connecticut even permit people to do from a kind of transfer on death scenario?
So Connecticut is pretty permissive. One of the things we actually do when we do an estate plan is, I collect information from the client in terms of all their assets. I tell them, again, most clients don't pay estate tax, but it's just as important for us to know how your assets are titled before we even decide on how beautiful these documents are going to be. We could have the best documents in the world, but again, if the assets don't flow through them, what good are they? So the short answer is that to the extent that clients have bank and brokerage accounts, we try to have them title it into their revocable trust as soon as we execute the revocable trust. And again, for any viewers out there that don't know, a revocable trust, it's like it's like taking property from your left pocket and putting it in your right pocket for tax purposes, income tax planning purposes. It uses your social security number as the tax ID number. So again, no additional tax filings are needed. Again, it doesn't give you creditor protection, but again, it protects you from probate. So right off the bat, any assets that we can easily transfer to a revocable trust, we do. Banks are not so easy always. I'm sure, Paul, you find that as well. They all have different forms. The clients sometimes need extra handholding in terms of making sure everything is titled properly. But again, it's something that we can get through. And in addition, we do have clients that have LLCs for various real estate interests, or other investment interests. So we then assign membership interests in the LLCs over to their revocable trusts. So we really try to fully fund the revocable trust as much as possible. There are some assets, so cars in particular. I just was speaking to an older client today. Going to the DMV could be a pain. I'm sure that's any state, Paul, right? So
Yes, yes.
so one thing that we're lucky about is in Connecticut, DMV, there is a TOD, transfer on death form. I could print it off my computer. My clients just provide me with a copy of their title or registration, plug in the VIN, brief description of the car. The client comes in, decides to whom the car should pass. They sign it, and we avoid probate on that asset also. I've actually heard that, I used to sort of toy with the idea of titling a car into the revocable trust. More recently, I've heard some other attorneys. Again, I don't have personal experience on it, but some other attorneys told me the problem is that sometimes if it doesn't get transferred out right away, and then someone has an accident driving the car after the decedent dies, after the trustor dies, maybe there could be liability on the other trust assets. Again, I haven't actually seen it in practice, but ever since hearing that, I've been extra cautious in saying, let's just do a TOD form, easy enough. And that's sort of where we stand on cars and
Yeah.
assets.
Yeah, super. Yep. Okay. And I know you have from a power of attorney standpoint, you have a statutory power of attorney. And I know um, I hear from lawyers all over the country, this bank, this brokerage firm is not honoring the power of attorney that my client signed for whatever reason. But I think that having a statutory power of attorney can limit some of that confusion because the banks, the brokerage firms don't have to examine every word of every power of attorney. Once the statutory power of attorney is submitted, third parties are more comfortable with it because it's a form the legislature created. So and again, that's one reason why it may be best to transfer those brokerage accounts and those bank accounts to the trust so that in the event the trustor or settlor becomes incapacitated, that successor trustee can step in and start handling everything. Do you see much resistance from third parties or financial institutions when powers of attorney added to them, or
So
not
I would,
so much?
yeah, so I would say, Paul, I agree with everything you said. Um, you know, Starting off, it's easier if we can have a trustee serving as opposed to someone under a power of attorney, because again, it's irrefutable. This person is currently acting as trustee or successor trustee, and there's no problems. The power of attorney form in Connecticut is statutory, so we should have less problems, fewer problems, but we still do. Just last week, one of my clients was an older woman, severe dementia. Her daughter wanted access to the safe deposit box at the bank. And in Connecticut, one of the line items is access to bank account. I forgot the exact wording of it, but again, if you look in the statute when they define it, it also includes safe deposit boxes. When the
Yeah.
daughter of the client went to the bank, no, 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 it needs to explicitly say safe deposit boxes. So we still have the issues.
Yeah.
There's no perfect
Yeah.
solution. So again, to the extent something could be in trust, we prefer it. And again, with a safe deposit box, sometimes it's good just to have a secondary person there for convenience purposes named on the safe deposit box.
Yeah, no doubt about it. Yeah, if parents trust their children, it's a good idea for parents to add that child or those children as having signature authority on the box. That eliminates all those power of attorney concerns, executor concerns. So I'm right with you there. Okay, now I want to move into the hot topic of the day, because, geez, I'm over 30 something years as an estate planning attorney. To say I've dealt with family dynamics is an understatement. I'll tell you my one story. Maybe I wish you could have been around, but it was a probate matter, and dad died, and he owned, I don't know, 30 or 40 pieces of industrial property. And he named all four of his children as his co-executors in his will. And for starters, each of his children had their own security guard at dad's funeral to protect themselves from their siblings.
Right.
So that was a rough one. And but I do want to get into kind of genuinely, you have a master's of social work. Yes, as estate planning attorneys, we see all kinds of family dynamics, both in the traditional family of a husband and wife who had a set of children, and in the blended family where husbands and wives who have their own estates and their own children, get married and one of them passes away, and there's some dynamics to be dealt with at that point. So love to hear you share maybe how you use your experience as a social worker to get through some of these family dynamic issues.
Yeah, and like you said, Paul, all of us doing estate planning work, we're dealing with it on a daily basis. Um, my approach really is I like to do it frontally. I ask the clients what assets they have. Then I say, tell me about your family dynamics. Who do you speak to every day? Which kids do you have problems with? Do you like your daughters-in-law? Do you like your sons-in-law? Who do you trust? Who don't you trust? Obviously, there's always the confidentiality issues we have to start whenever we're representing two people, but is there a side family? So the idea is that we really have to get a good idea of who our clients are as people, not just where their bank accounts are located and how much real estate they own. Because again, ultimately, a lot of the decisions, in to some extent, here's my bias, some even of the most important decisions don't have to do with the finances. They don't have to do with the passing of property. Who's going to be the guardian of your minor child and actually raise that child and help imbue values, your values that otherwise you would be doing? And sometimes that's the most difficult question, even just from a personal standpoint. If something happens to me and my wife, who should raise our children? It's a big question, and it's very hard to really get around that. But so what I like to do is I like to sort of present these issues to the clients, and then also do a lot of what if situations. One of the clients last year, actually, she called me the what if guy. She said, Tom, let's go to the what if guy. He's gonna show you all these things that we have to think about. And again, the idea is, right, if something happens to you, you might know that Aunt Phyllis is going to be wonderful for helping to raise the children. But is Aunt Phyllis the one that should be making the decisions about if they should be investing in Nvidia now, and at what point, they should be getting a down payment on their house? Maybe, maybe not. So the idea is that I try to sort of ask, who are the important people in your life? Who are the important people in your children's lives? And how can we sort of give everyone the best role to make your plan really work the way you want it to work? And it goes also along those lines. I ask the clients, who's going to give your children the car at the right time? Who's going to be too stingy? So again, we really like to sort of go through various scenarios. And then obviously we also have to think about possibilities. Maybe this is what we're thinking about when the children are younger, but as clients have children in their early 20s, perhaps they're already sort of seeing that, yes, this child will launch, may have his or her own family. And we start having to raise these other concerns that sometimes, unfortunately, I have to bring up the possibility, but your child might get married, it'll be wonderful, but your child's spouse could be a huge creditor. Perhaps we should be thinking about ongoing trust. But again, we get the idea of where the family is based on the fact also where they are right now. Are the siblings close to one another? Would they look out for one another? Is there already one of the siblings got married and everyone else doesn't like the spouse? We have to get an idea of all of that. So sometimes that could take longer than the discussion over a disclaimer trust and the estate tax exemption amount.
Yep. And when you on the aspect of Do you like your son-in-law? Do you like your daughter-in-law? Yeah, those are important questions. And I mean, every answer is different, but this goes into this kind of ongoing trust for children and potentially even ongoing for grandchildren after parents and grandparents pass away. I kind of feel like a real popular topic because, divorce happens often these days. I don't know exactly what the statistics are, maybe 40 or 50% of marriages end in divorce. It is what it is. Don't quote me on the statistics. But a lot of our clients, who are creating their estate plans, maybe one or both of the spouses have been divorced in the past. So divorce is on our clients' minds. And so even when they really love their son-in-law, they love their daughter-in-law, we have this conversation of, hey, if we can take a few easy steps here to make your children's inheritance divorce proof, and we're going to talk about that here in a minute, is that something that interests you? And the comment I often hear is, we love our daughter-in-law, we love our son-in-law, we treat them like they're our own children. But then the but comes in. But Paul, you just never know. And so it seems to be a really parents who have children who are married, they don't know, and they do really like the idea of keeping the assets in the bloodlines, protecting those assets for the children in the event the children inherit and then subsequently get divorced. So, is that what you're seeing in the people that you're talking to?
Yes, 100%. And to the extent that they're not yet raising it, I help them raise it. But I would even take a step back. The truth is, when we're doing what happens upon first spouse's death, you know, I bring it up because again, sometimes you see a married couple, they don't want to bring it up, but I say, we also have to think about what happens. I say, I put it back on myself. I don't want to think about what happens when I die. I don't want to know if my wife gets remarried, but it's a possibility. So I basically
Yeah,
say, you also have the possibility of locking in the amounts that are going to go to your spouse to make sure that no, Jonathan is my name, so Jonathan too won't get it, and Jonathan two's children won't get it. So I also bring it up that way, so they basically feel comfortable knowing, we're just talking about all sorts of possibilities here. And
yeah,
again, it's
yeah,
not because of divorce. Sometimes after one spouse loses their spouse, they get remarried, or
yeah.
if they don't get remarried, they might be easily, taken by someone and also be convinced to shift the assets somewhere else. So we do try to bring up those possibilities as well. We're all susceptible as
Yeah,
we get
a
older.
little trick that I use, because most of our clients are married couples. We represent them together. The couple is in all of the conversations. And so, you do have to be a little bit sensitive when you start getting into that. Okay, what if you die and these assets are available to your spouse and your spouse remarries? I'm thinking in my mind, okay, we have to have that discussion because that's just part of the estate planning process. So I always preface that sensitive discussion with maybe a question like, okay, Mr. and Mrs. So and so, with what I'm about to talk about, would you prefer that I give you the blunt version or the sugar coated version? And 100% of the time, they're like, "Paul, give it to me blunt." And so that kind of gives me permission to start talking about some of those sensitive issues. And and they're all in. They're like, "We need to talk about it." And then we're able to have a real comfortable discussion because yeah. I was watching a YouTube video where someone was interviewing an estate planning lawyer, and they were asking the lawyer, "What's maybe the three most important things that you talk about with a couple?" And I'd like those three things has to be, how are you going to leave your assets for your spouse if you die before your spouse? Because that impacts the future and what that surviving spouse's rights are the children potentially going to be disinherited because they were left to the surviving spouse in a way that surviving spouse might get influenced one day as they get older. So that's one of the key discussions. I think most couples, when they start talking about estate planning, I think they initially go to, how are we going to leave it to the kids? Who's going to be in charge of all of that? And they don't really realize the importance of that. How are we going to leave things to each other? I think they just kind of assume without thinking about it much that they just assume when one of them dies, the surviving spouse is going to own everything. But there's so much more and a big part of that, not only from a tax perspective, but just a non-tax family dynamic perspective as well. So, tell me a little bit about, as we talk about family dynamics, because usually family dynamics rears its ugly head when somebody dies. And so I want to know if you have any special tricks or social worker techniques, maybe when you're in a conversation with the surviving spouse and the children, and sometimes the surviving spouse is not the parent of the children, and there's just this perhaps a little bit of distrust in the room. How do you deal with that when a family member dies and you can sense that the parties, that you're not getting that warm and fuzzy feeling between the parties? What are some of your techniques that you use there?
So again, obviously, like you said, everyone comes out when someone dies, and again, they could be the children, stepchildren. You also get the nephews, the nieces that may not have spoken to the decedent for years, but they want to find out what's going on. So those aside, if we're talking about, sort of the nuclear family of the person that passed away, looking at all the people that would have gotten notice in the probate proceeding, I like to, first of all, obviously my priority is going to be the client that's being appointed as executor or executrix. But I do like to bring the entire family, to the extent that they're local, around the table. Not as much as they do in sort of all the movies where they read the will to the family. I've never actually done that, nor I've actually seen that happen in real life, but I do like to have an opportunity for everyone really to sit down and sort of get a general idea of what this estate administration process is going to look like, when people could expect to get payouts, and present the opportunity for people to ask questions. Why is this in trust for me? Why aren't I the trustee of the trust for my benefit and for my children's benefit? Because again, I think it's important to sort of address these issues head on so they don't fester. The
Yeah.
extent that the people sort of take it away and are getting angry, that's not good. Because again, they'll just
Yeah, and
spiral
you may take
emotionally.
it this step further. I even take it this step further. If I want to be involved in a probate, and there's 4 or 5 participants, I require, okay, this first discussion where we talk about the will and where we talk about the assets and we talk about the steps that need to take place in order to go through what we need to go through to get this whole thing settled. The beauty of technology now is, even if they're not local, we can get everybody on a Zoom call like this, and you're right, they can get their questions answered. We put everybody on a kind of a group email or a group website where, and I'm like, okay, none of you can call me by yourselves and say, don't tell so and so I'm calling you, but I need to ask you. Can't do that. I let them all know. Every piece of communication, it's got to be seen by everyone, and we'll keep you posted every step of the way. And what that does is it just eliminates some stress. You see the shoulders kind of relax. You see the participants saying, okay, I'm going to be kept informed. Nothing's going to be behind my back. There's not going to be any secret pact between the attorney and my sister. So I just feel like that communication, and that open and transparent communication, is just goes so far in an estate settlement um, process, even when those relationships are a little bit iffy to begin with.
100%. And again, for many people,
Yeah.
that's their first exposure to trusted estates law. So they don't know what to expect. I mentioned it before, Paul, my kids are on the younger side. I'm thinking there's a Daniel Tiger song that says, when you do something new, let's talk about what you do. That way, the idea is you have to sort of lay out the groundwork. This is what you could expect. You're not going to be getting your bequest in the next 3 weeks. No, that's just not how it works. First, we have to report things. So again, the idea is give expectations, transparency, and again, that's sort of the best way to address it. But ultimately, if someone's going to be angry and try to fight, you know, they're going to try to fight. So the idea is that we want to at least
Yeah.
embrace them to the extent we can and hope that it's not going to affect the personal relationships later. Because again, the estate will be distributed. Hopefully it won't affect the long-term relationship between, mom and daughter, for the next few decades.
Yeah, and I think it always helps. Some parents, um, I generally feel like if because having parents set up an estate planning documents, yes, it dots the i's, it crosses the t's, it says who's entitled to what, but it doesn't really convey the why. So always like it when I see parents communicate, whether it's just, having group conversations with the family, writing, letters of intent. Always like to see those parents kind of not only get the estate plan in place with all the legal instruments, but also which convey the kind of what's going to happen and who's going to be in charge. But I also like to see those parents convey the why somehow. Some parents they just and I respect it when that's their decision. They're like, nope, we're not going to tell our kids anything. And it doesn't really matter what happens. I'll be dead. So a lot of times people will give me the "I'll be dead" argument is what they say. But I really do think that communication with your children or grandchildren or whoever your closest loved ones are and your beneficiaries are and heirs are. I think, having communication with them and that while you can and while you're able and while you have a good mind, really can go a long way toward relationships of their survivors is enhanced. Certainly, parents don't want to leave things in a way where relationships are destroyed. So I think it's a combination of, yes, putting the good legal planning in place and then some communications with those participants as to why the parents did what they did.
Right.
So you see some of that stuff?
Yeah, certainly. Actually, while we're talking about sort of communication, I would also say, before I said one of the most difficult decisions that clients sometimes face is deciding on the guardian for the minor children. But another thing, actually, that we should just touch on, because again, talking about communication and one's wishes with regard to estate planning documents, there's also the advanced directives for healthcare decisions. And one thing that I feel that clients don't do enough of is really speaking in depth about their end of life decisions. Sometimes you know, sometimes I'm assuming, it's nice pillow talk at night for husband and wife to discuss it. But the truth is, are they also communicating that with their children, the extent that they really should be? So that's actually something that I think, in my view, it needs more attention. Because again, when we have a nice clean discussion around the table doing their plan, do they want the standard living will? They want to donate organs? Those are sort of discussions we have. But in terms of the logistics of really how long would you want to be on life support? At what time do you feel that living is no longer worth it for you? I feel like those conversations probably are not happening as often as they probably should. Um, Despite the fact that we are naming people in our documents to make these decisions for us, I don't know that we're doing an effective job of actually communicating those wishes beforehand.
Yeah, and one we touched on this point earlier. I want to touch on it again. It was one of those line items that you and I said, yeah, this would be a good item for us to this leaving things in trusts for descendants or for children. I'll give you my perspective, and then I want you to share your perspective. A lot of parents like the idea of leaving assets in a trust for their children, even if the children are mature, responsible adults, handle money well. One of the reasons is we've already talked about it, kind of attempting to make those inherited assets divorce proof. Kind of in my mind, if assets are left to the Jenny trust, then it's unlikely that Jenny or anyone else will mix up those Jenny trust assets with other assets that Jenny may have with her spouse. So if she does get subsequently divorced, Jenny keeps her trust. Jenny and her spouse split other assets that they accumulated during the marriage. That seems to be real important to parents. And I know there's other reasons to leave things in trust for children. have someone else manage it because the children aren't financially responsible. Perhaps even kind of make sure that when the children pass away, any remaining inheritance that's in the child's trust would pass along to the child's children. What are some of the things you're seeing and doing from instead of just leaving it outright to the children, leaving it in trust for the children? What kind of issues are you dealing with there?
Yeah, so in addition, I would actually say, spouses are one thing, but you also have to protect, I have clients that their children are physicians. Physicians get sued. The idea is also if you
Yeah.
want to protect from general creditors, not just spouses, make sure the assets are going to be in trust. Their children might be well off and might know how to handle assets greater than what they're going to be inheriting from their parents. But again, let's give the added layer of protection so that they don't have to scramble as soon as they think they might be sued, which again, we have to prevent fraudulent conveyances as well, obviously. But the idea is for most clients, it's easier to sort of start the assets protected than try to protect them later. So I sort of tell the clients, even if your children are going to inherit at the age of 50, we don't know what's going to be out there when they're at age 50. Are they going to be sued for something? Right. Is there going to be a bad marriage? Who knows? Maybe they'll be swindled. Maybe their identity is going to be stolen. Again, to the extent that we could put those protections in place, we usually encourage our clients as a default, let's put it in trust. There's always ways to get it out later if we need it out later. We can have an independent trustee. HEMS can be read broadly. So there's lots of ways to get it out. But again, it's harder to put it back in once you sort of leave it to your children outright. So my default is unless the clients tell me otherwise, and I tell them this is what I would like to do, but tell me where you'd like to change it. I say let's leave it in trust for your children. Do you want to have it go out at age 40? And if I say if it goes out at age 40 and your daughter's husband knows that, he's not going to file for a divorce till she's 41. Again, I raise these possibilities.
Yeah.
That way we can sort of
Yeah.
have a meaningful discussion. And again, like you said, sometimes, should I be blunt? So my way of doing it is I'm blunt right away, but I raise issues that they haven't even thought of, perhaps, or that they don't want to say. But if I say it first, it gives them a sense of comfort to basically say, okay, well, let's just take what you said a step further. Oh, my friend has this issue, so I let it be out there. Let's say I don't know your son, Gary, so I'll talk about Gary. And again, I don't know him, so no harm. But again, let's just continue this situation in this hypothetical and see where the clients take it.
Yeah. Yeah. I think if there's one thing that our discussion here today, hopefully let viewers realize is there's just so much more to, some people think estate planning is writing a will, but there's just so much more to it. There are so many dynamics. Yes, because sometimes people create estate plans and they stay in effect for 10, 20, 30, 40 years. We do have to cover a number of the what ifs in the original estate planning because life changes and family circumstances change, and yes, things can be reviewed and updated in the event of some significant life changes. But I think viewers are starting to realize, hey, there's a lot to this estate planning stuff, and it's one of the most important things people can do for their family. So as we wrap up here, I want to first thank Jonathan for participating today. By the way, I put his website in the description. If any of you want to check out his website, it's in the description below. So feel free to check that out. Jonathan, thanks so much for participating. I hope to do it again with you soon. There's a lot more we didn't get to discuss, and hope we get another chance to do this again.
Thank you, Paul. I really enjoyed the opportunity. Thank you.